Section 103, when importation begins and deemed terminated. Importation begins when the carrying vessel or aircraft enters the Philippine territory with the intention to unload therein. Importation is deemed terminated when A. The duties, taxes, and other charges due upon the goods have been paid or secured to be paid at the port of entry unless the goods are free from duties, taxes, and other charges, and legal permit for withdrawal has been granted, or B. In case the goods are deemed free of duties, taxes, and other charges, the goods have legally left the jurisdiction of the Bureau. Section 104, when duty and tax are due on imported goods. Except as otherwise provided for in this Act or in other laws, all goods, when imported into the Philippines, shall be subject to duty upon importation, including goods previously exported from the Philippines. Unpaid duties, taxes, and other charges shall incur legal interest of 20% per annum computed from the date of final assessment under Section 429 of this Act, when payment becomes due and demandable. The legal interest shall likewise accrue on any fine or penalty imposed. Upon payment of duties, taxes, and other charges, the Bureau shall issue necessary receipt or document as proof of such payment. Section 105, effective date of rate of import duty. Imported goods shall be subject to the import duty rates under the applicable tariff heading that are effective at the date of importation or upon withdrawal from the warehouse for consumption. In case of withdrawal from free zones for introduction to the customs territory, the duty rate at the time of withdrawal shall be applicable on the goods originally admitted, whether withdrawn in its original or advanced form. In case of goods sold at customs public auction, the duty rates at the date of the auction shall apply for purposes of implementing Section 1143A of this Act.
Section 106, Declarant. A declarant may be a consignee or a person who has the right to dispose of the goods. The declarant shall lodge a goods declaration with the Bureau and may be A. The importer, being the holder of the bill of lading, or B. The exporter, being the owner of the goods to be shipped out, or C. A customs broker, acting under the authority of the importer or from a holder of the bill, or D. A person duly empowered to act as agent or attorney in fact for each holder. In case the consignee or the person who has the right to dispose of the goods is a juridical person, it may authorize a responsible officer of the company to sign the goods declaration as declarant on its behalf. The goods declaration submitted to the Bureau shall be processed by the declarant or by a licensed customs broker, provided that for importations, a transition period of 2 years from the effectivity of this Act is hereby provided, during which subparagraph D of this section shall not be implemented by the Bureau. Provided further that after 2 years from the effectivity of this Act, subparagraph D of this section shall take into effect, consistent with international standards and customs best practices.
Section 107, Rights and Responsibilities of the Declarant. The declarant shall be responsible for the accuracy of the goods declaration and for the payment of all duties, taxes, and other charges due on imported goods. The licensed customs broker shall likewise be responsible for the accuracy of the goods declaration, but shall not be responsible for the payment of duties, taxes, and other charges due on the imported goods. The declarant shall sign the goods declaration, even when assisted by a licensed customs broker, who shall likewise sign the goods declaration. Section 108, penalties for errors in goods declaration. The Bureau shall not impose substantial penalties for errors when such errors are inadvertent and there was no fraudulent intent or gross negligence in the commission thereof, provided that in order to discourage repetition of such errors, a penalty may be imposed but shall not be excessive.